first panel discussion now begins.
The rules of this panel discussion is as follows. Presenters have 30 minutes to give their speech. The presenters will be given a 28-minute reminder with a short bell ring. When the 30-minute time limit is up, the bell will ring twice. The presenters should then end their speech. The discussants will be given a 13-minute reminder with a short bell ring. When the 15-minute time is up, the bell will ring twice. The discussants should then end their discussion. Afterwards, we will have a 20-minute Q&A. Each question in the Q&A session is limited to 2 minutes. All persons who would like to join the Q&A shall identify themselves by stating their name, the affiliated institution, and their title before presenting the comments or questions. There will be a 1.5-minute reminder with a short bell ring, and the bell will ring twice when the time is up. The attendants should then end their questions. If you wish to join the Q&A, you may use the microphone in front of you. Please press the button on the microphone while you speak, and remember to turn it off when you finish. If you have other questions or opinions, you can also use the speech notes placed inside the folder and pass it to the staff near you.
The topic of the first panel discussion is protection of the disadvantaged people's right. Let us welcome the Honorable Justice Luo Changfa to be the moderator of this session with great applause.
Thank you so much. Welcome back to the first panel session of this conference. We've just heard the rule of the speakers and discussants, but we already decided to change the rule. It will be shortened so as to make us more efficient and give us more time to further discuss the issues that have been touched upon or raised in our presentation and discussants' comment. This session follows the main theme of this conference. As we have heard from this morning's keynote speech, there is the very important minority protection issue. And this session focused specifically the minority aspect under our constitutional system. We have the pleasure and the honor to have very, the best, let me put it this way, the best, the most suitable persons to discuss these issues. Professor Zhang Wenzhen is professor at National Taiwan University. She teaches constitutional law, including comparative constitutional law, and she has authored so many papers and books. She'll be talking about constitutional protection of sex, gender equality with the focus on Taiwan Constitutional Court's leading cases. And we have the second speaker, Professor Evie Mona. Evie Mona is professor at National Donghua University. He is the most appropriate person to talk about the protection of indigenous people because he himself has indigenous background. And he has authored so many papers and academic works in this area, and actually having participated very actively in promoting the enhancement of the protection of indigenous people. We have two discussants. Their respective topics are a bit broader than the papers being presented by our two speakers. and therefore they'll be invited to take the floor after both speakers have completed their speeches. Professor Lin Chaojun is professor at National Taipei University. Chaojun will be talking about minority representation, mixed electoral systems, and semi-presidentialism, the case of Taiwan. So as I mentioned, this is broader than the speakers' respective topics. And Professor Liao Fute will be addressing preventing racial hatred and discrimination by implementing ICERD. This is against discrimination issues. So they'll be discussing right after our two speakers. And since our two speakers have their respective PowerPoint slide, therefore the others will be moving down there to listen. And then after they have completed their speeches, I'll invite all of them to come back and to start discussions. Before we move on, I would like also to introduce already you've known Yu Jie. Yu Jie is sitting here to help us. She's so kind to agree in translating or interpreting the needed participant. If any one of you would like to raise questions after our discussions, after our speeches and discussions in Chinese, it is okay. Yu Jie will be helping us all the way through our discussion part of this session. So let me invite Wenzhen to take the floor. Wenzhen, thank you. You have 25 minutes, not 30. A round of applause. Thank you.
Thank you, Honorable Justice Luo. And Honorable Justices, distinguished juries, it's really my honor to join this conference and then enjoy the opportunity to speak with you on the recent progress of women's rights in Taiwan. Women certainly is not minority in number, but it's certainly minority in power, structural minorities, as I would put. But as you can see in my paper, as well as the following time that I am speaking with you, we have made such a big progress in terms of women's rights and sex and gender equality. So this morning, you heard our women president speaking with you on her determination to push forward judicial reform, as well as to institutionalize concrete constitutional review, constitutional complaint in this country. So we had women president elected, the first one in 2016. Right now in our legislature, 40%, nearly 40% of the legislators on the national level are women. I think this number is quite good as compared to a lot of advanced democracies, even in the United States, in a lot of European countries. Right now, on this court, we have women justices sharing their time with us. In the conference, we have 4 women justices now sitting on the court among 15 justices. At this moment, is the time when we had most number of female justices on our constitutional court. Outside the government, 44 of those employed in labor market are women. Not so good, not so bad. Probably an average number of Asian countries and also advanced democracies. Literacy rates of men and women are very good and quite close, 99% versus 97%. So my interest is really to ask this very question: to what extent this progress in terms of advancement of women's rights in Taiwan, as well as a few shortcomings, has been made by the law, the Constitution, or most importantly, the case law of our Constitutional Court. Or rather, it has been the reflection of the changes in socio-economic conditions to which the law has barely contributed or has contributed not much. So I would begin with legal and institutional framework. And I would share with you there is a recent transformation in terms of legal and institutional framework, moving a little bit away from the Constitution to international human rights. Most importantly, the Convention on Elimination of All Forms of Discrimination Against Women, CEDAW. And following that, I will show you how much of our Taiwanese Constitutional Court's case law has contributed to the advancement of women's rights and sex and gender equality. And I would present with you three, I think, important, key, perhaps serious challenges facing our court. So the first, our Constitution, we inherited from Republic of China Constitution in 1947. There, it's a quite concise and brief constitution. Nevertheless, conforming to all the standard liberal constitutional democracies and protection of human rights. In Article 7, all citizens, irrespective of sex, are guaranteed with the equality before the law. And that's pretty much the only provision that our Constitutional Court could talk and touch upon when they face with sex and gender equality cases. Then, in the national policy chapter of the RRC 1947 Constitution of Taiwan, this is important. And then I believe that my colleagues, Professor Lin Chaojun, will link this point to the arrangements of parliamentary design and the sharing of political powers in our system, where in our 1947 Constitution, we already had women quota. So in all legislatures, all levels of legislatures, the Constitution demands a certain number of women must be represented. It was, and perhaps still is, revolutionary in a lot of national constitutions. And not controversial, I must say, in Taiwan, as in my generate some controversy in European countries where they would argue gender parity or this kind of women quota may violate sex or gender equality. During the 1990s, as our President and also Chief Justice of Constitutional Court, Justice Xu, shared with you that we had undergone a series of constitutional reforms, democratizations. There, two provisions were incorporated into the additional articles to the Constitution. Again, so the number of elected female members on each party list, so the party proportional system, must be no less than 1/2 of the total numbers of the nominated nominees by the political parties. So this is only for national parliament. And that is why you see my first PowerPoint where we have over 40%, nearly 40% of the national legislature has women representatives. And also, in Section 6, Article 10, there is one provision there in the additional articles to guarantee that the state shall bear the duty to implement, to protect the dignity of women, safeguard their personal safety, eliminate sexual discrimination, and further substantive gender equality. The word substantive here is important. I will draw your attention again when we meet with the case law. So as you can see, the provisions, constitutional provisions in the Constitution are really brief. Do not tell you much about the details of advancement of women's rights and sex and gender equality. So pretty much starting in the late 1990s and the early 2000s, there was this very pronounced big alliance of women's groups and lawyers' organizations push forward for advocating accession and domestic incorporation of CEDAW. And so you see in the 1990s, there was already the movement of gender mainstreaming, emphasizing the importance of, to the extent, gender parity, right? At least half of the associations, the governments, the institutions must be in power sharing with women. But of course, we did poorly at the time. And right now, a lot of committees, associations, public, private alike, would have 1/3 of those in decision-making power as women. So with all of their efforts, the legislature, we call Legislative Yuan in Taiwan, passed the accession on January 5th, 2007, and followed by the presidential signature. On February 27, the Ministry of Foreign Affairs attempted to submit the accession to Secretary General of the United Nations for deposition. Understandably, the deposition was not accepted. Yet, this setback was in no way disencouraging the NGOs and women lawyers, and even to some extent government, to domestically implement and incorporate CEDAW into part of our law. So in 2011, CEDAW's Implementation Act, in which all the rights enshrined in CEDAW and all the principles adopted in CEDAW were and are still given the status of law in our domestic legal system. In other words, right now it's okay for all the lawyers, government officials to apply CEDAW provisions into their day-to-day cases. And then since then, we have gone on to a few international reviews. We invited typically former CEDAW committee members to be in Taiwan to form an independent expert panel to look into where our laws, regulations complied with CEDAW provisions, principles, spirits, and rights, and so on and so forth. So this is our legal and institutional framework. And so now let me work with you to see under this rather thin constitutional framework, and perhaps recently better incorporated CEDAW framework, and how well our Constitutional Court has dealt with women's rights and sex and gender equalities. Again, a huge number of cases occur in the 1990s where, again, I would see this is really an institutional collaboration between the women lawyers, activists, and the Constitutional Court. So a few women groups and women lawyers use the constitutional litigation as a way to challenge those very old-fashioned, as I would see, we would see today, provisions in the civil code as unconstitutional. And Constitutional Court responded fairly well, advancing sex and gender equality in all those cases. So the first case, judicial interpretation number 365, where it used to be that if there's any parental disagreements on the children, and then the preference would be given to the father. And this was held unconstitutional by the court. And then the second case, where again, if for the community property owned by husband and wife, and if there's any uncertainty in terms of whether it's husband or wife owning the property, again, the old law, the previous law will always give the presumption of property owner to the husband. Again, this law was held unconstitutional. The third case, again, so it used to be that the residence of the wife shall be that of the husband. Right now, this is not the functioning law, and the court also held unconstitutional in that particular case. And the last case, again, it might sound odd to you, but whenever the government loaned a piece of house or land to the veterans, and when the veterans died, if he has a wife, no problem continuing with the loaning. But then if he has an unmarried daughter, that's okay. The loan would go on. But if the daughter married and then he had no son, then that's the stopping point of the loan. And you can see how this is a sex and gender discrimination. And the court also held unconstitutional there. So quite much progress, although the cases are not much. But then as you can see, the legislature at the time responded pretty fairly well to largely adhered the civil code provisions, along with many other regulations there. But doctrinally, I would say there is a problem. In all these cases, our court said that discriminations based on sex is to be constitutionally permitted if such discriminations are grounded on biological differences between sexes, or the differences in societal functions as the consequence of the biological differences between sexes. That's pretty much the phase, and still the standard phase that I am now teaching first-year constitutional law back in the law school, that the court used to strike down all the laws and regulations. But as you can see, as a fairly minded jurist, it's not clear at all. This is a strict searching scrutiny that all the sexual differences are not to be permitted, or it's really the kind of reasonable, scrutiny, or it's sort of intermediate. The court has never really provided an affirmative answer to that. And perhaps that is why in JY interpretation number 490, which was not the case, particularly targeting the constitutionality problems of the regulation that in Taiwan, in this country, only men going to the army, women are excluded. And so the challenge there was about Jehovah's Witness. But nevertheless, the court itself brought into this question about, well, precisely because they're permissible differences made either biological or societal functions due to its biological differences. So these differences are allowed. But it's not clear to what extent the law really look into those differences made by law in terms of the doctrinal significance. And in the since 2000s, there are a few key important cases. And this one in particular was treated at the time when the court delivered this case as a big victory, triumph, really, development at the time. So in this decision, the court held unconstitutional a law imposing criminal fines or up to 1 year criminal penalty only to those engaging in sexual transactions for profit. As you could understand, mostly of those would be women, but not those purchasing for sex, as you could well expect, mostly would be men. So the court striking down that. And perhaps even more importantly at the time, this decision was quite celebrated in Taiwanese constitutional and legal community, is that the court further to said that they look into the empirical studies showing a predominant number of those engaging in prostitution were women of lower social and economic status. And therefore, the provision, although on its face, does not really distinguish men or women, right? On its face, it's not sexual differences. But if you look into the substance, then this provision was clearly in violation of sex equality. And so this decision was celebrated at the time as the court seems to us at the time adopting substantive equality. And also, more importantly, in terms of the scholarly methodology, allowing the court to look into empirical data to justify structural inequality. Yet, immediately follow, not immediately, but a few years following this decision was JY interpretation number 6066. And a few years down the road, in 2015, the court issued another case, JY interpretation number 728. And I would say if the previous case, JY interpretation 666, was a celebrated decision, this interpretation number 728 was a decision really criticized heavily by the women's groups and feminist scholars in Taiwan. So in this decision, it was involved a statute concerning the ancestor worship guilds association. So if you go around Taiwan, you see there's not only worships for the gods or goddess, there are also a few worships for ancestors. So the big group of families would join in particular days for that kind of worship. So understandably, it's a private family kind of association. And in those associations, typically there would be an election, but it's not the kind of official political election, but an election for the one as a representative to worship their common ancestry. The petitioner was, in this case, a married daughter who was not permitted to be a successor as a representative for the worship association. She argued before the court that the provision was a de facto discrimination against women, as most associations, as the result of election custom, among others, assign only men as successors, the key representative for worship. So note that in the law, there's no provision saying, men were accorded with privilege. No, it's really the private associations, their own private charters. But the result, the consequence of culture, customs, and the 100% permissibility for associations to forming their own customs and rules, the result of that will be predominantly, as you could imagine, women excluded for that kind of position. And so the court in that case, I would say disappointing to a lot of women lawyers in this country. The court held the provision constitutional on the grounds of freedom of association. After all, these worship associations are private, mostly grounded by the extended families. Property rights, as those associations own the buildings, the lands of the ancestry. And freedom of contract, as an ancestor worship association or guild, is an association formed by the properties donated by the founders for the purpose of providing services for ancestor worship or other forms of worship, even though such a disputed provision may constitute differential treatment in substance, since it is not arbitrary. It is not in conflict with the principle of sex equality embodied in Article 7 of the Constitution, nor does it infringe women's right to property. Again, I was inviting you to look into the additional article where the government is imbued with the duty to advance substantive equality of sex and gender. And in previous cases, the court was celebrated by recognizing substantive equality. But this following cases where, again, the court seems not to stand firm on its supporting ground of substantive equality. So was this a doctrinal setback? And then was the earlier doctrinal differences the court affirmed only reasonable? It was, after all, not a searching or strict scrutiny. So that was the issue left by this very decision. And it's interesting that the court, in its decision, referring to CEDAW as a normative ground for the government to further taking a review to the entire ancestor worship system and try to revise it, try to have something anew that would be in compliance with sex equality. But the court was not willing to hold the law that is unconstitutional at the time. So, you heard our Chief Justice briefing you on this very important case. And since Chief Justice already touched quite much, then I don't spend my time into it. And this was a man, an all-gay man, litigating his case for the past 20, 30 years, and finally won the victory 2 years ago. This was the court holding the hearing and then the brief press conference for the decision. Okay. And the only thing I want to show you is that in this very case, the court does recognize the classification based upon sexual orientation as a classification that needs to be worried. And then they sort of heightened the scrutiny into that. And that was the key basis on which they sort of rule our civil code, our civic code provisions failing to provide equal marriage for same-sex couples as unconstitutional. But we need to ask, is really, okay, so if the difference between, if the difference of sexual orientation would be triggering the kind of heightened scrutiny for the court, how about, why not we go back to the sex and gender differences, right? So are they the same as the differences of sexual orientation now, or are they different? Note that it's understandably okay that the court did not answer to this question, but this is certainly the challenge, I think, posing very seriously for the court in the future case law. So the first challenge in lying behind this very court, and perhaps all the courts following it, is the doctrinal clarity of sex and gender equality in terms of on which ground they are going to rule in terms of doctrinal consistency, or how they are going to compare this with the differences of sexual orientation. And the second thing I think is also why women groups and lawyers have this move away from Constitution towards international human rights, CEDAW. Because as you know, CEDAW recognizes substantive equality. And CEDAW also recognizes government has a duty to eradicate the customs and rules that are not consistent with sex and gender equality. And our court, in interpretation 7208 for the ancestor worship, it's difficult because ancestor worship is quite deeply in our tradition. But still, that is really the target that CEDAW vows to eradicate. So that's the challenge in facing our court to really tackle directly for women's equality issues in private sphere. And last but not the least, I think our court's case law have not directly confronted with the strong protection of women's reproductive and privacy rights. So earlier there was a rather conservative decision on recognizing the constitutionality of criminalization of adultery. There, although the court recognized certain reproductive and privacy rights, but they have not faced up to the problems in terms of structural difficulties between men and women in terms of sexual and reproductive rights and privacy issues. So with that, I'm doing okay, and I will conclude my report. Thank you.
Hello, everyone. Thanks to Grand Justice Law. And dear distinguished members to the Justice and all the guests here. First of all, I would like to say that I am so blessed today because my topic has shown my argument, the reconciliation, which is just echo to Grand Justice McLennan's this afternoon's speech, this morning's speech. So I'm going to talk about the indigenous laws today. If you read my paper, you will find no discussions on any constitutional interpretations, just like the Professor Wen Zhen's presentation. The reason for that is that I didn't know today is we are celebrating 70 years for the Constitutional Court. I'm sorry about that. I'm trying to say within past 70 years, there is only one interpretation regarding indigenous rights, which is 719, number 719. And that case is not related to my talk, so I decided to not including in my papers. Is that a good thing or a bad thing? I mean, there's no cases going to the Constitutional Court. I think that one thing I would like to talk about today. So before I start my presentation, I would like to also give you a brief information about myself. I'm from the Static Indigenous Peoples, which is located in central Taiwan, Ren'ai Township in Nantou County. And one of the thing about the Static people is we had a war against the Japanese colonial government in 1930s, which is led by my forefathers, my grandparents, which is the leaders. Okay, so start. I'm talking about the civil law, the state civil law and indigenous legal tradition, especially focused on the land governance. And actually, although I said there's only one case about indigenous people in the constitutional interpretation, but actually there is one case right now currently under review by the Constitutional Court, which is about the hunting cases of one Bunong peoples. So this is just a quote from the one papers, I mean the news. There's one Bunong called Wang Guanglu. He was hunting with a shotgun because his 92-year-old mother wanted to eat fresh game. But after all the judicial remedies, he was still sentenced to 3 years and 6 months in jail. But this case, just like I said, is under review by the Constitutional Court. So this is one case about the criminal cases. And another case, which is very important, not only for indigenous people, but also for the law studies. Because in last year, 2017, the government issued one regulation, which is to demarcate indigenous traditional lands. But once this regulation has been issued, a group of indigenous people protest in front of the presidential office. And up until today, they are still there to protest. Because while government guidelines only call for demarcating public lands, protesters maintain that private land should also be included. So there's a conflict about how does the law should be implemented. And this is one thing. This is the main issues I would like to talk with you today. So these are the two cases. And anything about indigenous peoples about the law, I think just like we read the Grand Justice paper, you divide it into 4 areas. And also in Taiwan, I think we need to start with the indigenous relationship with the state. And it is very interesting to see that if we look into the history, indigenous peoples in Taiwan has gone through different eras, which has been described and identified by different terms used by the government. Just like the savages we used in Mandarin, we call Fanren. And the next term is Gaoshazu, used by the Japanese government. And after World War II, the ROC under KMT used the term Sanbao. And after the constitutional reform in 1997, the Constitution revised the Sanbao with the term 原住民族. But all these terms, I think, especially for the savages, Taksokuzoku and the Sanbao, these terms are all legal fictions and legal discourse based on the colonial legal source. I think it is very important to say that each of these terms, especially Fanren, especially Sanbao, they have reviewed the position of the government toward indigenous peoples under the idea of progress, because the government used this term to prove the denigration of indigenous cultures. And after this, and they can assert the non-indigenous people is superior to indigenous people racially and culturally. And after these 2 steps, the indigenous people cultural differences, in fact, just like we recognize the culture is all equal. But after these 2 steps, the government has completed stigmatization of indigenous cultural differences. And this has brought to the result that naming as a legal tool with the political end. And this political end is to exclude the indigenous people has the right like other peoples. So if you can see these transitions, the term of indigenous people has only started to use in the Constitution after 1994. And under the 4th constitutional reform in 1997, we added 原住民族. This 族 means the plural. So we used to only identify individual 原住民. And after 1997, we now recognize 原住民族 as a collectivity. But before that, we can see from the first contact through the 1930s, it's almost more than 400 years. Under different colonial regimes, they all recognize or identify indigenous people as savages. But only indigenous people, like I said, indigenous people only existed in our Constitution more than 20 years. So a term used for 20 years compared to a term used more than 400 years, which has a great impact on the relationship between indigenous people and the state, even the general public. So a lot of populations in Taiwan, they still think indigenous people are inferior culturally compared to the non-indigenous peoples. So because of this historical development, which led to the indigenous movement started in 1980s, and because of indigenous movement has led to the constitutional reform and the following legal constructions. So I would like to explain to you, for myself, I think indigenous movement in Taiwan has already gone through 3 different stages. And the first stages happened in 1980s through 1990s. And this indigenous movement, along with the Taiwanese social democratic movement, which led to the constitutional reforms. And in 1998, the first indigenous legislation was passed, which is focused on the education. I think it's very similar to the common law countries, that like the US or the Canada. The first legislation always focus on education or other social welfare. So after the constitutional reform, we saw the first changing of parties in Taiwan. And during the first changing of parties in Taiwan, the then president, he signed politically a new partnership treaty with Taiwan indigenous peoples, which to echo the international indigenous movement carried out in the UN system. And on his second term, in 2005, the then President Chen, he made a political declaration saying that Taiwanese government has a nation-to-nation relationship with indigenous peoples. Back that period, a lot of peoples, including indigenous peoples, all has little expectation on these two political documents can have any result. But in fact, because of these two political movement and the political commitment, we have the Indigenous Peoples Basic Law passed in 2005. And because of the Indigenous Peoples Basic Law, which can have the following the indigenous legal construction all the way through until now. And luckily, 2 years ago, our President Tsai Ing-wen, she delivered a national apology to indigenous peoples, just like the Australia and just like the Canada. But the differences between Taiwan and Canada and Australia is that if we look carefully to Canada and Australia, their prime minister only apologized to specific event or to specific issues, especially on residential school, which in Australia, they define the term is the stolen generations. So they are very focused on the assimilation through education. But in Taiwan, the President Tsai, her national apology is not focused only on one aspect. After her apology, the President has set up an Indigenous Historical Justice and Traditional Justice Commission to lead the following, afterwards the work towards indigenous rights protections. So very important to see is historical justice, not only the transitional justice. So just like I said, after 2005, we have the Indigenous Peoples Basic Law. So right now, from my observation, there is truly a legal infrastructure is emerging. Socially speaking, we have seen that the indigenous legal tradition has become legitimization through the court decisions. And also in the administration aspect, the mechanism of free prior informed consent are taking place in a number of different cases. And culturally, we have seen the implementation of cultural manifestation, expression, and practices through a number of different legislation, like Cultural Heritage Act, like the Indigenous Traditional Intellectual Acts. And also, because of this implementation, the indigenous cultural heritage has moved into self-governance. And political aspect, we have seen since the 2013, Judicial Yuan has established Indigenous Ad hoc Tribunal to deal with indigenous cases. And also, right now, in the Indigenous Peoples Basic Law, indigenous tribe can establish tribal council as an indigenous public juristic person. So these are the legal infrastructure we have seen after 2005. We have the Indigenous Peoples Basic Law in place. But it seems that I'm sharing with you a lot of good things about indigenous rights, but in fact, the situation for indigenous people are not that good. So it seems to me that indigenous people, after all these years' movement, we have arrived at some point. And at this point, we have seen no government implementation yet. So that's why we have conflict. So especially on the indigenous cultural practices, like I'm focusing today, in the land management and utilizations, and more specifically speaking, like indigenous hunting, fishing, and gathering, I think these three different terms are most common for indigenous people across the globe, which has the most conflict with the state law, also in common law and civil law countries. So in criminal cases, after the court has set up the ad hoc tribunal, we have seen a lot of different indigenous criminal cases has brought cultural defense against the state's law as their argument to protect our hunting, fishing, and gathering cases. And in civil cases, a lot of indigenous litigants has claimed indigenous legal traditions and cultural claims to make their argument. So in my paper, I have used some of the cases here. Actually, indigenous claims for traditional territorial land rights in the legal disputes are not limited to particular litigation such as civil, criminal, or administrative cases. What I meant is that indigenous case cannot only judge or review from one aspect, because indigenous people the indigenous law has no divisions. Like in 2005 Magus cases, in this case, the defendant is in violation of Forestry Act. And also in 2013 Katiput cases, the indigenous people was prosecuted as the obstruction official duties. But in these two cases, indigenous people all make their strong claims based on traditional territorial land rights. It is saying that even though the indigenous person was prosecuted based on Forestry Act or obstructing official duties, but all indigenous peoples are making their claim based on traditional territorial land right to saying that they are justified based on the original title in a sure way. So even though either cases ended with a not guilty judgment, nonetheless, neither one of the court had taken traditional territorial land right claim into account. So, which brings me to think about what is the position of indigenous legal traditions within the structure of state law. So if we look to Article 1 of the Civil Code, it says that if there is no applicable act for a civil case, the case shall be decided according to customs. If there is no such custom, the case shall be decided according to the jurisprudence. So but we look to the Indigenous Peoples Basic Law, Article 30, Paragraph 1, saying that the government shall respect tribal languages, traditional customs, cultures, and values of indigenous peoples in implementing judicial and administration remedial procedures for the purpose of protecting the lawful rights of indigenous peoples. So we can see that generally speaking, indigenous land dispute before the operation of the ad hoc chamber of indigenous court, most cases were decided pursuant to the principle of civil code without taking indigenous legal tradition into considerations. Specifically speaking, I use this case as an example. The case actually is about a land dispute, but even the litigant has met a strong evidence based on legal traditions, but the court's position towards societal customs maintain statutory principle enshrined in the Civil Code, which is societal customs are not part of the state law unless recognized as customary law or factual customs in the positive law. So under this principle, the legal traditions of indigenous people are mostly excluded in the judgment. Even though Article 757 opened a window for the inclusion of rights in land created by customs, indigenous legal traditions are still left out of the loop. And one thing I observe is that there's a gap. The gap is in Article 2, because the Civil Code of Article 2 saying that only those customs which are not against public policy or morals shall be applied to a civil case. And also in Article 72, saying that a juridical act which is against public policy or moral is void. So it seems that we have an existing integral and unitary legal order that has continued to build up psychological barriers. These psychological barriers about the customs used in civil code refused to acknowledge and apply indigenous legal traditions within state legal systems. But if we look at one of the cases issued by the Supreme Court of Taiwan, it's about a smart goods. I quote some of the judgment here. The court says that indigenous people traditional customs have their own historical origins and cultural significance in accordance with inter-ethnic equality, sustainable development, taking the viewpoints of multiculturalism and cultural relativism to achieve the mutual benefits for ethnic relations. Indigenous people's rights in undertaking traditional customary practices within a reasonable ambit in their traditional territory should be appropriate respect in order to safeguard indigenous people's basic rights. But unfortunately, we haven't seen this idea has any concrete application in the following cases, both in criminal and civil cases. So if we look to legislative context, one thing in indigenous people's basic law saying that Article 20, the government recognizes indigenous people's right to land and natural resources. However, what is the concept and actual content of indigenous land and natural resources rights? We need further legislation. We need court judgment. We need precedents and theoretical viewpoints. And indigenous legal tradition which build up indigenous land tenure system have not accorded a legitimate title for indigenous people. That's the fact. But we have additional Article 11 and 12 to the ROC Constitution. And we also have indigenous people's basic law. And we also has already incorporated two international human rights covenants into domestic law. So all these three documents, we can say, they all affirm the legal status of contemporary indigenous rights are based upon the ideas of collectivity and sui generis. So let's look to the Human Rights Committee General Comment 23. Article 27 specifically protects indigenous people as well as their traditional territorial lands. And Comment 23 states that states must enact positive measures to protect these rights, likely including the enactment of domestic legislation, maintenance of a functioning judicial system, and respect of treaty rights. So the core issue is we need an effective understanding of indigenous traditional territorial land rights. And we can resort to Article 15 of our Constitution because the Article 15 of the Constitution says that the right property shall be guaranteed to the people. And I believe this article surely also protects indigenous people's property rights. So Article 15 and along with additional Article 11 and 12 of the Constitution establish direct guarantees for such rights of indigenous people. No need for subsequent specification. So very important is that judicial work on the understanding, interpretation, and translation of indigenous rights cannot be detached from the conditions of the indigenous legal traditions in which it takes place. So I think we need a sui generis regime which can echo to the three documents. So the meaningful conceptualization of indigenous traditional territorial land rights depends upon engaging in the process of indigenization, the active pursuit of a distinct development path, culture, and identity. So I'm saying that actually in the judicial branch, I think we need an evolutionary interpretation of right to property, both in the Constitution and the general law should be adopted. So my conclusion is that I think since we have the Constitution, we have the basic law, we also have the two international human rights covenants. And Article 20 says already protects indigenous right to land and natural resources. And this right to land and natural resources, we should understand in a sense which includes, among others, the rights of members of the indigenous people within the framework of communal property, which is also recognized by the Constitution of Taiwan. That concludes my presentation. Thanks for listening. And last word, I teach you static words. Mahuai Manu Balai. Thank you.
Thank you so much. May I invite my panelists to come forward? Pointed out the perhaps setback or the areas that need to be corrected or improved from certain perspectives. And Evi Mona provided us with very useful background information about the indigenous peoples and their culture. And he also pointed out the difficulties still encountering indigenous peoples and threatening the indigenous tradition. We have, as I mentioned, two discussants. Our two discussants are not going to specifically addressing the indigenous people or gender issue, but to have more broader discussion on discrimination issues. So let's begin with Cao Jin. You have 13 minutes. Thank you.
Thank you very much, Grand Judge's Law. I'm sorry because I was writing this paper in a rush, so there are some mistakes. So I do mistakes first. Please refer to page 133. Paragraph 1, line 6. Interpretation 718 should be interpretation 719. This just Professor has mentioned. This is only one case. Our Grand Judge has to deal with Aboriginal people's rights, relevant to indigenous people. And another one is the paragraph 2, line 2. again, I don't know why I was writing I wrote 718. This is not my birthday, not my wife's birthday, but it should be the 748, I'm sorry. And also probably pre-move to page 135. Paragraph 4 and paragraph 5, both 9.1. Interpretation 748 should be changed to interpretation 721. So this is my great honor to attend this conference. Thank you very much for Grand Justice's invitation. And in particular, this is my great privilege to read Professor Zhang Wenzhen's terrific paper. As just our chairman has made comments, she used very concise and clear way to introduce the development of the gender and sexual equality issues in the last 2 or 3 decades. And which the paper also gave me a very excellent starting point to discuss one point I would like to talk about. It's about which institution is a better one to protect rights in Taiwan, especially in the case of equal protection, especially in the hard cases of equal protection. Please refer to the Professor Zhang Wenzhen paper on page 125. He told us a very good example. He said when various NGO groups, they would like to challenge the constitutionality of the Article 1089 of the Civil Code. They persuade 150 congressmen to help them to submit constitutional petition to the Constitutional Court. So that case is launched by the congressmen. They held various NGO groups to challenge the constitutionality of a specific law. But it's quite interesting. If those congressmen, they think this law is dubious, they should modify it. But I don't know why, what's the reason. They just send a complaint, petition to the Constitutional Court. And then finally, they succeeded, getting a good result, the result they liked. But on the other hand, the interpretation 748, our Chief Justice have mentioned this case in the morning. Professor Zhang also mentioned it before, several minutes ago. This case, in this case, Grand Justice recognized the constitutionality of the same-sex marriage, and delivered this case 1 year ago, more than 1 year, I guess. But until now, the congressmen failed to do anything, not even have the serious debate in the Congress. So what can we infer from this contradictory phenomenon in Taiwan? So put this question in another way. What kind of role we would expect the Congress to do in terms of protecting people's rights, especially in the case of equal protection? Interestingly, roughly 1 decade ago, a very influential and famous NYU law professor, Jeremy Waldron, in his very famous paper, he argued that, he said, when the full condition had been made, legislature is a better institution than the court to protect rights. Although I'm not totally agree with his argument, but here he at least reminded the people in Taiwan there's a very important issue probably we have ignored. Is the important status or important function of the legislature in terms of the enforcing rights. So probably the interpretation number 748 is a good example to support Jeremy Waldron's argument. But here I would like to focus on the legislative electoral system regulated in Taiwan's constitution. Actually, I just want to discuss two mechanisms regulated in our constitution. The first one is the aboriginal seats in our constitution. the other one is a threshold, or the 5% threshold for a political party to share seats in the Congress. Because we have a foreign distinguished guest, so probably I should introduce our election system first, but because the time is limited, so I just read my paper to make things make it easy. Please refer to the page 133, the next paragraph. With the 2005 constitutional amendment, Taiwan formally adopted the mixed member electoral system for the Congress. Under this system, people can cast 2 votes, one for the district list, the other one for the party list. But more importantly is the legislator from the district list occupy the 2/3 of the seats. So it means only 1/3 of the seats from the party list. Besides this, there are additional 6 aboriginal seats. So in total 130 seats. They are special aboriginal seats, 6 seats. So for the political party want to share seat from the party list, they have to pass over the 5% threshold. So these are 2 issues I would like to discuss here. The first thing regarding the Aboriginal seats is a very interesting. I don't know quite exactly the reason. It is a multi-member district, and more importantly, is across the whole nation. It's a whole nation. And it divide the Aboriginal into 2 kinds. One is they call the lowland Aboriginal people. The other one is the highland Aboriginal people. And this distinction is based on the pre-1945 household registration. It means this registration is based on the record built by the Japanese colonial government. So already more than 70 years passed. So we can imagine how is a great scale of the demography have changed in the past 70 years. But we still use a distinction based on 1945. So this is the first problem. Another problem is why Aboriginal people, even if we entitle them with the right to elect their own representative, it is the whole country as the base of the district. Why didn't we follow the New Zealand's model, divide the whole country into 6 different Aboriginal districts? So this is another issue we can talk about. But these 2 points have been mentioned by other scholars before. Here, I would like to talk about probably a more difficult issue is this kind of the district, the design of the Aboriginal seats, design of Aboriginal seat, is based on a kind of assumption. Only the same color of skin of the people can elect their own. If this system is only allow the Aboriginal people can be elected to be represent the Aboriginal people. So it's based on the assumption only people with the same color of the skin can represent the interest of their fellow countrymen. So this kind of principle has been criticized by the American U.S. Supreme Court very famous case, Shelby-Reno. So this is probably another issue we should talk about. And the fourth probably the defects of this system is, since the Taiwan's mixed member electoral system, in the single plural district, we have not adhered to the 1 person, 1 vote principles. So in a very close election, the 6 Aboriginal seats can play a very decisive role in deciding which party can win the election. So it means this system probably cannot protect the minority rights. On the other hand, it would hurt the majority rules. So these are about the aboriginal seat, the seat of aboriginal seat in Taiwan's constitution. Regarding to the 5% threshold for a political party to share a seat in the Congress, actually Taiwan's Grand Justice have delivered an interpretation. In the interpretation, as Judge mentioned, 721, Grand Justice declared this system constitutional based on the following three reasons. The first reason is this system is not against the constitutional order. The second reason is this system to prevent the fragmentation of the political party system from happening in Taiwan. And the third reason is in practice, some small party can pass the threshold to enter the legislative yuan, to enter the Congress. But here, I just would like to raise two questions. The first one is the 5% threshold is from the German system. And the German is a pure parliamentary system. But Taiwan, we are not. We are the semi-presidential system. So it's a question, what kind of mechanism we should adopt in a semi-presidential system? Or put the question in another way. Is better we have a 7% or 3% threshold to meet the goal of the semi-presidential system? And the second question we can raise about this system is, unlike German, our German system, they use the party list to determine the proportionality component in the party list to determine the whole seat a party can obtain in a particular election. But Taiwan, we do not adopt this system. In the party list and the district list are parallel lines, so they have no influence on each other. So in this Taiwan system, it means the small party cannot get as strong as the German system, the leverage in a particular arena. So if our system is more favorable to the majority party, how come we cannot reduce the threshold from 5% into 3%, for instance, to protect the minority parties, minority interests? So these are two questions we can raise about the current 5% threshold. So just to make a conclusion, I think it's very important to facilitate diversity and to protect the minority rights in any society. But in the past, in Taiwan, probably we focused too much on the role function of the court. So nobody cares, at least for our legal scholars, or pay much less attention to the legislature. Probably in the future, if we have chance, we should spend more efforts in studying those designs regarding the legislature. Thank you much for listening.
Thank you very much, Cao Jun, for having identified a number of quite important and perhaps to some extent controversial issues, including mixed member legislative electoral system, as well as the Aboriginal representative, and 5% threshold. I think our speakers might have something to say later on. Let's move to Futa. You have 13 minutes. Thank you.
Okay, thank you very much, Your Honorable Justice Law and Professor Zhang, Professor Wimona, and Professor Lin, and Dr. Chen. But first of all, I would like to express my special thanks to Honorable Justice Zhang Senlin for the invitation and the spatial tolerance for my detours to, apart from two presenters of any of the details of my presentation. Yeah. I'm trying to focus on my talk on preventing racial hatred and discrimination by implementing an international treaty, human rights treaty, we call it ICED, International Convention on Elimination of Racial Discrimination. And I try to divide my speech into 4 parts. The first one, I try to call as there's no law and no cases of constitutional interpretation. Because we can find that it's guaranteed by Article 7 of the Constitution of Taiwan that all citizens of the Republic of China, irrespective of sex, religion, and race, class, or party affiliation, should be equal before the law. And also, it has been emphasized by we that Article 10 of the Constitution affirms that the state affirms cultural pluralism and should actively preserve and enforce the development of Aboriginal language and the cultures. And of course, there was some protection of the ethnic groups. But it's very interesting that the Constitutional Court of Taiwan has many interpretation concerning right to equality. But, however, we may say that there is no single constitutional interpretation focusing on racial equality, although we have Article 7 of the Constitution. And then we also, in general law or level, we have a very special law, special provision, right, at Article 62 of Immigration Act, which provides that any person should not discriminate against people resident in Taiwan on the basis of race. And it also offers any person whose rights are trespassed due to the discrimination can file a complaint to the competent authority which enforced this article. That is the Ministry of Internal. But it's also quite a very strange that we can find no complaint by far. So it's a very strange legal system in Taiwan that we have our constitutional provisions. We also have a very special law, but there's no complaint and there's no constitutional interpretation on the racial equality. And so I have a feeling that because we have no further law to implement constitutional provisions. And so I will move to the second part of my speech where I will talk about Taiwan and the I-3rd. The I-3rd was passed on December 21st of 1965, and the ROC signed the convention in fact, in 1966, and ratified in 1970 in November. And it was before the ROC was forced to eventually leave the UN in 1971. And this is, in fact, the I-3rd was the only core international human rights treaty ratified by ROC by 1971. And therefore, maybe we can suppose that the I-3rd has domestic legal status in Taiwan, but very interesting that the ratification was 48 years ago, and very few people know about it, including judges and perhaps including Grand Justice. That's my personal view. So I have to say that it's very difficult to implement the I-3rd if there's no special legislations. And my personal view is that there could be two approaches to have been proposed to ratify. To implement this convention. The one is to enact a racial equality law, and the other is to legislate an I-3rd implementing act. And no matter which one, either way can achieve the goal of racial equality. But however, I'm suggesting that a better approach is to incorporate I-3rd standards of protection into domestic legal system, so to be found as a basis law to protect racial equality. And then my third part will try to introduce or talk about what I understand about preventing racial hatred and discrimination in I-3rd. Maybe I could try to find three parts of very important details of the I-3rd. The first part is the preamble of the I-3rd, and emphasize that any doctrine of superiority based on racial differentiation in scientifically false, morally condemnable, social injustice and dangerous, and there is no justification for racial discrimination in theory or in practice. anyway. And they also ruled in Article 1 that the term racial discrimination should mean any distinguishing, exclusion, restriction, or preference based on race, color, descent, or anything, which has the purpose or effect of nothing or importing the recognition, enjoyment, or exercise on an equal footing of human rights and the fundamental freedoms in every fields. And the third one is that a very key provision of which is Article of the ICERT. It reads that state parties contain all propaganda and all organizations which are based on ideas or theory of superiority of one race or group of persons of one color or ethnic origin, or which attempt to justify or promote racial hatred and discrimination in any form, and that the state has to undertake to adopt immediate and positive measures designed to eradicate all incitement to or acts of such discrimination. And to this end, they have to do, all country parties have to do regard to principle embodied in the Universal Declaration of Human Rights and express their force in Article 4 of the Convention. In fact, the Convention asks the contracting party to do three things. The first one is that to regard racial discrimination is a crime. And the second is to prohibit organizations which promote and incite racial discrimination. And the third is to prevent the public authority from promoting or inciting racial discrimination. And I've tried to say that the ICERT committee, in fact, puts much concerns on the ways to treat foreigners and the issues related to racial discrimination. So I would try to bring you some cases about the that I had delivered by the ICERT committee. The first one maybe is the ways to treat foreigners. Perhaps in the one case is that in UK versus the Netherlands, Moroccan citizens visit the municipal, and they or some at that occasion, some 20 people had gathered outside the house and shouting that no more foreigners, or others said that would set fire to the house if he moved in and would damage his car. And for this case, the committee has opinion that the remarks and the tweets made to the petitioner constitute incitement to racial discrimination and to act violence against persons of another color or ethnic origin, and therefore, of course, violation of the ICERT Convention. And another case is that about Germany, against Germany. There's a German culture journal called Electoral International published an interview with a people who was a former financial senator of the Berlin Senator. And at this interview, the people claim that most of the Arabs and the Turks in Berlin have no productive function and are neither willing nor able to integrate or reject the German state, make no effort to educate their children, and they just produce new title of hand-squaff girls. And of course, the committee found that the sovereign statement contained ideas of racial superiority, denied respect to the Turkish population as human beings, and depicted generalized negative characters of Turkish population. It also incites racial discrimination in order to deny the Turkish population access to the social welfare, including with the Article 4 of the Convention. That's the two cases. And another case is about racial discrimination speech. This is about a case against Norway. A group of people that's in 2000. A group of people held a march in the commemoration of Rudolph Hess, and the leader, one of the leaders, made a speech in praise of Adolf Hitler and Rudolph Hess, and they're referring to both citizen and the jury and the robbing, rape, and the killing of Norwegians by immigrants. And he called for Norway built on a national socialism, such kind of anything. Yeah, and of course the committee, the ESO committee held that there had been a violation of Article 4, and it contains, because the statements contains ideas based on racial superiority or hatred. Yeah, that's basically some cases that can be made reference to this convention. And the last part I should like to talk about is that since the Article 4 of the ISA Convention is quite important, then we will try to trace back how this article be implemented in Taiwan. Because Article 4 of the ISA requires every contracting state 3 obligations. The first one is that among them, one is to prevent the public authority from promote or inciting racial discrimination. And of course, it's definitely what Taiwan needs to do with no need of further discussions, because that should be prevented in public authorities. And another issue is to enact racial discrimination as a crime. And I have to say that Articles 153 and 309 and 310 of the Criminal Code do not directly focus on racial discrimination. And therefore, there's no law, in my view, there's no law to do all that racial discrimination as a crime. That's perhaps that we should do in the future. And the third and the last issue is to prohibit organizations which promote and incite racial discrimination. As far as I know, that Article 2 of the Online Crime Prevention Act refers criminal organization as to a structured, permanent, or profit-seeking organization formed by more than 3 persons involved in threats, violence, fraud, intimidation, or offense that carry a maximum principal punishment of more than 5 years imprisonment. But Article 4 of the ISA refers to racial discrimination organization to those who promote and incite racial discrimination. Therefore, only when a racial discrimination is regarded as a crime, a group of people involved in racial discrimination can be prosecuted as a criminal organization. So because of time limitation, I think I'll stop here. Thank you. Thank you very much.
Thank you very much, Fute, for your discussion on the all forms of racial discrimination. Now we have 15 minutes for our discussions. Well, the time does not allow us to have very interactive discussions. So let me do this. Let's collect questions first, and then we distribute the remaining time for our speakers so that they'll be able to decide what to answer and to what extent in what time frame to address those questions. Before I open the floor, let me start by asking a couple of questions for our speakers. For Wenzhen, there was discussion by Cao Jun about 5% threshold for political parties to be able to have their members selected to the legislative yuan. It is about political party, but does it have any implication for the protection of women? I'm not quite sure that this is quite okay for the protection of weaker parties, disadvantaged parties. And talking about disadvantaged parties, there have been discussions of discrimination of various minority or disadvantaged people in a legal system or in a society. Do you think there is any lessons to learn from different, for each other, for the protection of gender? Probably there are approaches developed in the context of anti-discrimination discrimination against all form of racial discrimination, things like that. So any mutual informing values for various specific discrimination of minorities or disadvantaged people. And for Evimona, Cao Jun mentioned about the whole country as a district for the election of certain group of indigenous people. Do you think there is any constitutional issue involved? What perspectives should a person who does not have indigenous background, strong indigenous background, to look into the issue? So this is first point. And the second point is about the very interesting suggestion that you mentioned about having some kind of sui generis regime under our legal system. So probably this is an opportunity for you to elaborate a little bit more about the nature of such sui generis system. Is it some kind of treaty between the government or the state and the indigenous people, or is making it a binding, very strongly binding effect, or is it some kind of norm being put at the constitutional level so that it should be specific enough for implementation and strong enough to force the implementation? Let me collect questions from the floor. If at this moment you're still formulating, yes, I'm sorry.
Yeah, I actually had a question about the Aboriginal representatives in the legislature and a comment or question for Professor Lin about it. So I assume that the way you described it, you were concerned about this sort of presumption that the Aboriginals could only be represented by Aboriginals. And so I took that to mean that Aboriginals can only vote in those elections and not the general districts. And if that's correct, I guess I wanted to ask you, isn't there, that's a concern, but there's also a kind of general benefit from having a quota system for minorities like this. That is, it's not just about the representation of the Aboriginals. It's not the only interest. The other one, of course, is for the society as a whole to sort of have a legislature that looks like the society, and also to get epistemic variety, if you will, or the information from all kinds of different people. So I guess it's a question. Are those interests important as well? And if I'm correct about the system, is there any discussion about the disempowerment, in some sense, of the Aboriginals because they're not free to vote for others?
So, Richard.
Thank you very much. Thank you for your presentations, all of you. I have a question for Professor Cheng and a question for Professor Mona. The question for Professor Cheng is about, if you can tell us about the history, the reason why that rule of parity, it's not quite parity, close to parity, why that was included in the Constitution. What was behind the drafting intent? The question for Professor Mona has to do with the question of reconciliation, which was the subject of your discussion. And of course, reconciliation is the concern of law. So at the level of constitutional law, what is possible to help reconcile peoples? But it's also a question of society. So law in society, what are we doing at the level of society to help reconcile peoples? And my question for you is, do we know what the teaching is like in schools about indigenous peoples? I was struck by the contrast you raised in terms of the way indigenous peoples used to be referred to and the way indigenous peoples are referred to today, from savages to indigenous peoples. And I could imagine that once upon a time, language used in elementary or high school textbooks wasn't indigenous peoples, it was something else. And so I'm wondering today, what is the language that is used, and how is the question of reconciliation addressed at that level of society, not in law, in the level of society? Thank you.
Thank you so much. I think we do not have time to have more questions. We have to give them not necessarily enough time, but fair time to respond. So you have 3 minutes. We have to stop here at 10 to 5. 10 to 5. I was told by the organizer, so I have to be very strong in this. So you have 3 minutes.
So I will respond to Richard's question first. So I think the close gender parity provision was adopted in the ROC Constitution as well as the constitutional amendments in the 1990s was because I think women, I would say elite women lawyers and women politicians were strong, both Chiang Kai-shek and his wife, and then elite women in the party in the early Republic China. And then as I show in my presentation, the women lawyers. But then again, it's the enhancement of women elite in the political system, not necessarily the advancement of all women's rights in all corners of the world. So I think that's the one. And I'm really inspired by the second question Professor Law asked. I think, so you see, there are quite a number of cases in the 1990s with the Constitutional Court, because at the time, we still have a lot of discriminations in the law. But once these legal discriminations were eradicated, the court must face with the discriminations on the ground, de facto. So if the court lacks the kind of jurisprudence and doctrine of substantive equality, recognize the de facto inequality, then the court will find difficulty to deal with those cases. That's my point. And I think this corresponds to the indigenous rights and discriminations, because for colonial system, it's really the things on the ground. So there's really not legal discriminations there. And then those cases had not entered into the court's docket. So if the court has not developed substantive equality or the doctrines de facto, then I see the difficulty of the court further on to advance those minority rights. And I think it's also institutionally connected to what the President Tsai has said about the institution of constitutional complaint. Because Awi Mona would say there are a lot of cases in those criminalization of gun owning and shooting cases, but they are all the cases. It's not a problem of law, sort of on its face discriminalizing the indigenous peoples. It's really the application of the law. And so lacking the constitutional complaint as a system, these cases will not enter into the Constitutional Court. And the last is the 5%. I think the problem, again, in a lot of small political parties, the representative and organizers are typically still men. So having more of them are not necessarily to see more of the women in the parliament. So there is a lot of conflicting interests and designs in the parliament.
Thanks for the question, and I'll try to answer in an appropriate way. So first of all, I like to say, essentially, the division of indigenous status for me in the Constitution is unconstitutional, because the only division for the plains and mountain indigenous peoples only describe according to the political representation. But if you see to the additional article, there's no written description on indigenous people with mountain and plains. So the only division is only to the political representation. So for me, I think that I agree with the Professor Lin, that is very truly outdated. Even right now, intermarriage between different indigenous nations, the tribe you belong to is still follow your forefathers. Even you were born in Taipei, you are still identified as the mountain indigenous peoples. So that's truly absurd. So I think that's the issue we have to deal with. And answer to the reconciliation, I think if we, legally speaking, what I'm trying to refer to as through a generous regime, I think the one idea is we can borrow from the UN Declaration on the Rights of Indigenous People, because it says that indigenous people have right to access to customary laws. So when I say through a generous regime, it should be under the indigenous legal traditions, legal framework. And one example is that we have one legislation saying that it is the Protection Act for the indigenous intellectual creations. And for a lot of people, especially for indigenous people, that's the legal system which is parallel to intellectual property system. So if we can build up this indigenous intellectual creation legal framework, I think we can also build up another the generous regime to protect indigenous rights. But for a reconciliation, it is very sad to say that even though it's already 2 years past since the president delivered her apology, I believe there is, to some extent, in Taiwan, some of the general public still don't have any idea about national apology. I think that's the first thing we have to reconcile. So I agree with, I think if we can achieve reconciliation in the level of society, then we can achieve the reconciliation legally. So, and also you are saying about the school, the education. And right, actually the first indigenous legislation was Indigenous Education Act, which was enacted in 1998. Even we have this legislation, but in the school system, indigenous knowledge, indigenous education was still to see is like a 附属的 subordinate to the mainstream education. So even we have this act, we still cannot use our language to teach educations. But luckily, we revitalize our languages. So I think we are on the right track. So under the presidential office, there are 5 groups to advance the historical justice and the transitional justice. And one of the group is reconciliation group. So those groups are focused on the reconciliations. Thank you.
Thank you very much. 1 minute.
Very much for Professor Ginsberg's question. I think the problem in Taiwan is we have not taken the indigenous seeds, these questions seriously. So that's the problem. I agree with you, we can use the quota system. Actually, I failed to mention, in our constitution, we have a regulation. In the party list, there should be at least more than 1/2 of the representative should be female. So some people say we can use the similar mechanism, use the party list to protect Aboriginal people's interest. So yeah, so probably you can discuss this question later.
Thank you very much. I would like to thank my panelists, 5 of them, 2 speakers, 2 discussants, and Yijie, sorry, I do not give you opportunities to speak. Let me invite you to give them another round of big applause to thank them for excellent presentation. Thank you so much. Thank you. So we conclude our session. Thank you.